Hi, this is Damon Pistolka, host of The Faces of Business, where I talk with interesting people, sharing life and business experiences to entertain, engage, build community, and provide information to help others succeed. If you're interested in learning more about one of our guests or how we are helping business owners generate wealth and build businesses they can sell or succeed at Exit Your Way, you can find more information on our website, exityourway.com, or by contacting me directly, Damon at exityourway.com. I hope you enjoy the show. All right, here we go. Take two. I thought we were live a minute ago and we weren't, but hey, welcome to the Faces of Business. I'm your host, Damon Pistolka. I'm excited for our guest today. We have Eric Sarver here from the law offices of Eric M. Sarver. We're going to be talking about employment law challenges and answers. And Eric, thank you for being here today.
Damon, thank you so much. It's a pleasure to be on your show. As I said when we were not live, and I meant it, and I mean it now too. It's really great to be here, and I'm looking forward to our conversation.
Yeah, we're going to have some fun. Now, I tell you what, and then this is for people that are using StreamYard out there, because there was an annoying habit in StreamYard where it was not mirroring your camera. So if you look right on in the real world, you look left in the video world. They have fixed that. Go into your settings and change the mirror setting, because Eric asked me about it and I hadn't bothered to look at it. So thank you, Eric, for that tech tip and helping us get this straightened out.
My pleasure. You know, I'm not one. It's usually I was telling you before, I get accolades for my legal analysis acumen, legal skills, but usually the text is not my strong point. But maybe I'm picking up things here and there over the course of my life. So I'm happy to be of assistance.
Yes, well, that was a great help today. So, Eric, I've got to always like to start out. Tell us a little bit about your background in law and employment law, and what really drew you into it.
Yeah, sure thing, Damon. Happy to oblige there. Well, so, I was born and raised in New York. I was born in Brooklyn, and my parents moved to Long Island when I was a kid. So I grew up in a suburb of New York. And I always kind of had this interest in debating and discussion and just in advocacy as a kid. And I found it very fascinating to me. And, when I got older, I knew I wanted to be an attorney. I just had this hunch when I was even a young boy. And I saw it on TV and I saw some relatives who did it for a living. But when I got to college and law school and I saw what types of law you have that you can practice, employment law really spoke to me, Damon, because it's very much like a human drama type of situation. It's an area of law that I think really makes an impact on people's lives. We spend so much time either as an employer building our company, building our brand, to work hard to employ people, or on the flip side, being an employee somewhere. So I was drawn to also the human drama, but also just to the myriad issues that come up. I like how it's really involves a lot of strategy to figure out the best way to comply with the law or defend against a lawsuit. So I was sort of, I think, drawn into it for that human interest component.
Mm-hmm.
Yep.
Oh, that's cool. So going through your career in employment law,
yes,
what is one of the strangest cases that stick out in your mind that you can talk? I mean, that in generality, right?
Right. Yeah. I think how much time we have here. No, I'm joking. So yeah, a couple. I'm trying to keep it as vague as possible, but I'll say that and it goes back a way, right? Because I started practicing employment law in January 1999, and worked a couple of small firms. Started my practice in 2001. So I had, I think, a couple of strange cases. One that really kind of jumped out at me was when it was a company and they had a bunch of employees. They were paying them, overtime, not keeping the proper records. And then one of them actually, who was a plaintiff in the case, ended up having mob connection ties. And a coworker had to report that. And so the person who reported it was getting terminated for a different reason. But it was it involved a possible whistleblower situation, because the person with the mob connection, and it's I guess I don't want to say informal mob, I don't want to say the small mob, but like a side mob, not like a big mafia, So it involved whistleblower issues. It involved it got a possible RICO claim. that I don't really handle. But so it just,
Mm-hmm.
and the employer was kind of caught in the middle of all this, didn't know going into it. It actually came out in the midst of discovery. So the case settled before trial. But God, that was just such a crazy, yeah.
Oh yeah.
We don't even talk
A
about
lot
that
of
much
twists and
because,
turns.
I try to keep it like, but that was one of my probably wildest cases. It came on and started out as a wage and hour issue and quickly went in other directions. So,
Yeah. Yeah.
mm.
And I'm sure that as you now, first of all, do you normally represent companies or employees in your practice?
Yeah, no, it's a good question. Thank you for asking that so I can clarify. So I spent many years representing the employees exclusively from, I'd say, 1999 to 2000, maybe 12 or so, about 10 years ago, or
Uh-huh.
2013. And then in 2013, I kind of changed my practice a bit to the point where now I represent mostly the employer. I'd say I represent the employer about 90% of the time. I represent a
Hmm.
handful of employees, usually in very high stakes negotiations. So it's not quite litigation. Of course, I
Uh-huh.
check for any kind of conflict check.
Yeah.
You say executives who either are negotiating their compensation or they're perhaps negotiating severance, or they have a possible claim and they want to explore enhanced severance instead of that claim. And
Okay.
lastly, if say executive might be accused of wrongdoing and they think they're being railroaded, I can defend them in keeping their job. So, but
Yeah.
mostly I represent the employer,
Okay.
the company, the management side.
Yeah.
Yeah.
Okay.
Mhm.
Cool. And that I'm sure when you're doing it that way,
Mhm.
you kind of get both sides, and it helps you on to for defending either side too, because you can kind of keep the perspective.
Yes, absolutely true. When I talk with employment counsel, let's say like right now I have a couple of cases that I'm representing the employer on, so I'm defending the employer. And when I talk to opposing counsel, often I can either see the direction they're going in, like I can kind of read between the lines and
Hmm.
tell, do they think they have a strong case, or do they think they don't have a strong case? Because I remember using certain techniques based on, if the facts were on my side, or the law was on my side, or if neither was on my side. Although I tried to select my cases, very discriminate, very exclusively. But I often, I find I defend, as I mentioned, companies could be in federal court, state court, mediation, arbitration. Like what I do is I try to get into the mind of the plaintiff side attorney. And so, I even times even will tell them, I represent some employees as well. I have for many years, and I understand that when you're representing someone, this is a big concern. And so my client's perspective is this. So why don't we talk about? I think it kind of it puts them at ease. It doesn't present it as if we're mortal enemies here. We're just two professionals, doing our jobs. And I've been where they are, and I'm just trying to say that I can tell when a case might be going south for these reasons, or so it's been helpful. And it's
Hmm.
also whether it's defense or compliance. I do a lot of compliance work also, which is right. That's sort of the proactive side. That's the helping business owners to follow all the different federal, state, and municipal laws that govern everything from wages and hour to overtime pay to discrimination. Because if I can help them to follow the law and then have those policies in writing and communicate with their employees, and I can probably spend much less time with them than I do in litigation. Not that I don't love my clients, but I'd rather see them spend less money on compliance and then hire me back for other business law needs or employee handbooks than be in the trenches with them for 8 months, a year, 2 years, however long it takes.
Yeah. Yeah. Because employee litigation can take an awful long time.
Sure can. And it really has an impact on everything from the sale of a business, to due diligence in that process, to, let's say, attracting investors. If you're a startup company and you're looking to
Yeah.
raise money and you've got, a large discrimination suit against you that maybe could have been resolved, or a wage and hour suit because the employer didn't follow the tip pooling or overtime or commission rules,
Hmm.
be very problematic. So yeah, I'm happy to help my clients. If you're in New York, and even in New Jersey to some extent, I can help with the all that stuff.
Yeah. And when you talk about that, that's one of the things that a lot of business owners, I shouldn't say neglect, but don't really understand that any outstanding litigation going into trying to sell a business, raise money, there's several instances where you want to just take care of that kind of stuff ahead of time, so you're not you because you really can't get it done with that kind of thing, because if it's open-ended in any way, that it's going to kill a lot of your efforts to do that, because of the risk it creates. So you mentioned a couple things here, and we're going to talk about non-competes too. Sure. But there have been a tremendous amount of changes in the state laws across the United States dealing with wage and hour, especially in contractor kind of situations and other things. And you talk about compliance. What do you see are the toughest compliance issues your clients are trying to do correctly now? What are some of the toughest issues that they're dealing with in compliance?
In terms of wage and hour overtime situations, or in terms of
just overall, what are the compliance issues that you get brought to you the most?
I would say, Damon, that believe it or not, one of the ones that was very, very prevalent in all of 2020 and 2021, that's still even prevalent today, has to do with the COVID-19 rules and regulations and protocols. You still have a lot of outstanding state laws, and they vary from laws around, the infectious contagious disease policies in place to health and safety standards. I get called in a lot for also issues around like paid leave. And a lot of states are changing their paid leave laws. Paid family leave, paid sick leave, paid grievance leave, right? And then of course, so I'm getting called in a lot of that. And there's quarantine leave that's now, less of an issue, but has been a big thing for my clients. So definitely number one, all the COVID related laws, including laws around existing laws around like compliance with the ADA, right, with the Americans with Disabilities Act. But now, with COVID, you have people that are claiming that their long COVID is a disability, and it is in fact. And how do you accommodate that? How do you accommodate people that who can't come back to the office when, because of a condition they have that might not normally be deemed a disability, but that condition plus COVID could be very deadly. So you stop people with asthma who are not necessarily deemed, disabled, having this ADA claim. So definitely a lot of that. And then I guess the third issue has to do with discrimination, compliance with the laws around, not being able to mandate arbitration anymore for sexual harassment claims or gender discrimination. I see a lot of clients that get tripped up because they have arbitration claims now still in their employee policies and contracts. And then maybe lastly is just the fact that, with like compliance with different non-compete laws in different states. I know we'll get to that later, but you've got states now saying that, if you have a minimum salary threshold, you need that to have a non-compete, or you can't have it with hourly workers, or you can't have it with anyone in California. So really, that all of that comes into play, especially with the remote workforce, work from home. You've got people now working all across the country, and employers have to know, how do you comply? What's the compliance on all those issues in each state that their workers work?
Yeah, and we'll ask some questions about that. You went back, you said something here a while back about arbitration not being able to do mandatory arbitration. Explain that a little bit more, because that sounds like a pretty prominent change that we need to be aware of.
Absolutely. Yeah, sure thing. Happy to explain that. So, in the last few years, I'd say probably in the heels of the Me Too movement, there's been a lot of push towards laws. A lot of states actually have had laws enacted which basically preclude an employer from requiring that their employees, take a dispute around sexual harassment, sexual discrimination, or gender discrimination into a mandatory arbitration setting. So usually an arbitration clause, it might be in an initial employment agreement, it might be in a severance agreement, in fact, but it basically says that, if the parties essentially have a dispute and they can't resolve it amicably, that instead of going to court, they agree to an arbitration process, maybe with the AAA, the American Arbitration Association, or with an employment discrimination, with like JAMS or dispute. So a lot of laws are coming up in different states, and a lot of states are saying, no, you can't force people to arbitrate when it comes to sexual harassment, nor can you force them to have like a non-disclosure around those issues. The idea is that these are issues of public concern, and they want people not to be silenced, and they want to be able to have a voice to. So this has been picking up a lot in different states, and even in fact, there's a bipartisan bill, going through the federal government and Congress this year, which is said to repeal arbitration as a mandatory clause. It's called the FAIR Act, and so So this is something that we're seeing a lot more of now. What happens is that employers don't realize that, and they use a lot of times people reuse their templates. They think, oh,
Oh
why
yeah.
did right? I've had this employment contract, I'm using it for 20 years now. So when I hire, Susan or Fred, I'll give them this to sign. But I always encourage my clients who work with me, let's meet every year. Let's update our employment agreements, update, our non-solicitation clauses and our restrictive covenants and our employee handbooks. So,
Yeah.
but that's a big issue now. Really, you're finding that, and it's the challenge is that an employee may want to go to court, and the employer tried to say, no, you signed this agreement to arbitrate. And so the courts are starting to invalidate those clauses and saying you can proceed to court, as is.
So now this is the question, and you may not be able to answer it because it could be different situations. But if I have something like that in an employment agreement, does that make the whole employment agreement not valid anymore? If I have one like that and they throw it out and say, well, that's not right in the employment agreement, we can't go with that. Does that mean that everything else has gone on to that employment agreement?
Yeah, it's good thinking, good question. Usually not, because usually when people draft contracts, they have different sort of the miscellaneous provisions clauses, and when they say things like, like they say, this is the full contract in of itself, and they might say, that this is the headings are not in any particular order, but usually there's a part that talks about how if any one clause or provision of this contract is ever, struck down, void, nullified, that the others, the other clauses.
Okay.
In full force and effect as a fully. So the short answer is, the only time that might happen, let's say, if an attorney, drafted a contract and didn't have that. But honestly, I've been doing this for a very long time, and every contract I see, has that.
Good.
Clause, so.
Yeah, I was just curious as you were saying that. I was like, well, I hope that doesn't throw the whole thing out. So.
It's a good question, and honestly, people have tried to make that argument. Although one could be creative in arguing, one could argue that that the contract may have been coerced, pressured, that the whole contract in of itself was one of adhesion, right, where the people didn't really fully have the same level of bargaining power, and they might be able to point to the arbitration clause as an example, like, hey, I was forced into this and forced into these other clauses as well. But that's kind of, I think, a very high standard of proof, uphill burden to show. And if the contract language says in paragraph 16 that if this is if the arbitration clause is void or any clause is void, the rest stands. So usually a court would say, no, it's striking out the arbitration clause and the rest stands as is.
Okay, cool. Mm-hmm. You brought up another thing too. Now when we talk about that, so in those type of situations where you can't have employees to agree to arbitration, basically doesn't mean you can't not use arbitration, doesn't preclude you from using arbitration, but it doesn't force anyone into using arbitration.
Good point. And it's usually in regard to certain issues, right? Usually regarding discrimination or wage and hour overtime. So if you, let's say, have an employee and there's disagreement about, let's say, their parting pay or their commissions, you're allowed to use arbitration in those settings. It's the cases that are of public concern, like overtime violations, sexual assault, sexual harassment in the workplace, and discrimination. But you're absolutely right, and it's an excellent point, because my challenge often is, to make sure that the language in the contract makes it clear the parties can voluntarily consent if they so choose. And how do you make it clear that, each side was even in that one side wasn't sort of de facto, right, forced into this. So they'll say, so I often, I'll include clauses in my contracts with my clients that encourage the company, it encourages the employee to have this contract reviewed by an attorney. It used to be, I noticed the trend years ago, right? I know maybe you've seen this too, Damon. I know you do a lot of work with businesses. I feel like there's a trend years ago to try to get employees to sign agreements without an attorney. They thought an attorney was going to push back and it cause problems. But now, there's a big push to an encouraging effect of employees to have an attorney. That way, they can't claim that they're forced into any of the clauses, or the contract itself. So.
Yeah. And I think that's a great point. It's that is a really, really good point, because if you don't encourage them to have somebody an attorney review it,
yes,
and getting that third opinion, at least you're making your best attempt for them to get the advice that they need.
Right.
And
Absolutely.
that's really good. So now we move into a couple other things, because you brought
Sure.
up another topic, but the remote workers. Now
Mm.
this is man, this is a can of worms that I just
Oh,
don't, I don't know how the heck employees are doing, because you can be sitting there today in New York City with people in all other states around the
mm-hmm.
globe that
Mm-hmm.
are wage employees, not just
Yes.
contractors. What I mean, how what are
Yeah.
you seeing employers really because it's just like, it's mind-boggling to me think that I've got employees in 27 states when they were all in the city around me,
Absolutely.
4 years ago.
Yeah, I'm seeing this a lot. A lot of companies, my clients are industry agnostic, so they're everything from technology and advertising
Yeah.
to restaurants, to doctor's offices, to now some of my clients can't go remote, right? If they're a restaurant, let's say, they're
Yeah.
mostly on the premises, or if they're a
Mm-hmm.
construction company that constructs things. But for my clients in, let's say, marketing, advertisement, business consulting, like it is really a can of worms. That's a great way to describe it, David. It's actually a bit of a Pandora's box, if you will.
Yeah.
What I'm seeing is that I think like a lot of employers rejoice in a sense. They said, "Oh my God, this is great. We all were remote during the pandemic. We got our technology up to speed. We got Zoom. We got live stream with the mirror now and the camera. No, I'm just kidding,
Yeah.
joking. But we got all this stuff going on. We can do this." And they said, "We're going to get rid of our office lease, save money on the commercial lease, save money on
Yeah.
property, and all that stuff." The challenge is that, like, a lot of them didn't realize that, you have to follow the laws that govern where the employee lives and or works. So if they work in, let's say, I'll take an example. I'm in New York City, as my office is located, right? So employee lives in Connecticut and works in the office 3 days a week in New York, right? The employee is bound by New York law, right?
Yeah.
Let's say the employee is remote. Let's say they're remote, though, they're not hybrid. They could be working entirely where they live in Connecticut. If they live and work there, then you have to follow Connecticut's laws around everything from, what is the minimum salary threshold to be an exempt employee, right? To not have to pay overtime and under that state's law, or one of the factors. What are the laws around non-competes, as I mentioned? I know I come back to that a few times. It's an important topic. Are you now working with an employee in a state where they can't give a non-compete because their salary is too low by that state's threshold? So you really have to know all these different laws around everything from paid leave. I've seen Florida companies where they hire New York people and they say, "Oh, you don't get, paid maternity leave because we're in Florida." Well, it's not true. The person's in New York. It's a whole different ballgame. So I'm really
Mm-hmm.
seeing a need for companies to get with an employment lawyer, get with an HR company, and really get into compliance. Otherwise, what they think they're saving in office rent, they're going to pay in penalties, fines, lawsuits.
Yeah.
From so it could be a wild success, and if done right, correctly, or a total mess if done wrong. That's where I come in to try to help companies follow those laws.
Yeah. I get one last question that was brought up to me a while ago about that. Have you seen employers hit with workers' compensation claims with home-based remote workers?
It's funny you say that. I haven't seen it personally with any clients yet, but I've certainly been reading about this a lot and seeing it in the different cases that it actually very much is a potential liability to be concerned about, because you have an employee, let's say, works for you, and if they're forced to be remote, right? If it's your telling them, like, employee,
Yeah.
X, you are to work at home from now on. Um, let's say, like, they trip over some wires that they set up because they have their computer now with a
Yep.
router and extra wireless. Then yes, you can be on the hook for that. I've heard stories from colleagues where they said, "Hey, guess what? We've got someone now, and they broke the
Yeah.
shoulder working from home, tripped over their own, and it's a question of, well, what is at the workplace?" And it's sort of, it is, in a sense, it's the new
Yeah.
workplace. So you definitely have to be aware of that and mindful. And it's just one of the reasons. Now, the interesting there too is that how do you make that place, Damon, safe, right? If you're in if you're in an office, you got people come in and make sure that there's, the carpet's laid out flat, any wires are up against the wall.
Mm-hmm.
You really don't want to be knocking on employees' doors, and saying inspection and
Yeah.
checking where it's kind of inappropriate. But that's an issue. It's this new work laws is like an issue where there's a lot of compliance issues that come up, and we have workers' comp and employment insurance for different states. I'm seeing
Yeah.
and hearing it all. I'm seeing and hearing it all.
Yeah. I bet, because it's opened a lot. I mean, and for some businesses, it's really been a blessing because they can, you can hire talent outside of your area, which is,
Mhm.
I mean, is extremely valuable for some of these places.
Yeah.
And then for some of the employers, the employees as well, because
Mhm.
I can be living in Montana, working a remote job that's in, Silicon Valley or New York City, where you're at,
Mhm.
where the
Yeah.
wages are much higher for a similar position because of
Mm.
the cost of living. And
Mhm.
I can be making out much better if I'm in one of those places. So yeah, the interesting stuff. So
Mhm.
as you,
Mhm.
as you look at this, we've talked about there's two other subjects, and non-compete is one of them. We're going to talk
Right.
about the non-competes because I think that's fascinating. The other one that I've seen is the changes in contractor slash W-2 employee categorization, or whatever you want to
Mhm.
call it.
Yeah.
How much is that hitting your clients, or has everybody pretty much said, I can only use contractors, very limited, or what are some of the changes you've seen that have made it challenging to stay compliant?
Yeah. That actually is a great question. And to answer your question, unfortunately, a lot of my clients are going to get very, very hard on this front when it comes to independent contractors and employees, right? Misclassification. I say that like there actually been different changes. The law, I mean, there are certain criteria, Damon, certain standards that have been in place for a long time that different state departments of labor use, the IRS uses to consider if you are
Mm-hmm.
an employee or an independent contractor. And usually the factors have to do with like who has been the main, the control, who has the autonomy, direction, and control over the person's logistics, their schedule, their finances, right? Who's calling the
Mm-hmm.
shots here, so to speak. And so these criteria have been pretty fixed for some time. But
Yeah.
now what's happening is like that certain states are passing certain laws that say that if you are a gig economy worker in like this field, right? Like I know this is moving towards drivers and such, that you are in a newer wide. They're broadening the class of people who some states are considering to be employees. So California, for example, is
Mm-hmm.
broadening to say if you work in this type of position, right, you must be a W-2 employee. And so the bigger companies, Lyft, Uber, right, drive companies are really pushing back against some of these laws. I'm seeing laws in Rhode Island and Massachusetts that are either passing or on the about to be passed that are again trying to just like broaden the net and who's an employee. Even if those workers might have their own choice, they may have their own jobs, they might be able
Yeah.
to drive for competition. Maybe they drive Uber twice a month, 1 month, and 6 times the next, So I'm seeing a lot of clients of mine who are very confused because they don't know where their workers stand. And also, we're seeing much higher levels of enforcement. I think the departments of labor in various states, lost, this is my theory, they lost revenue a lot in 2020 and 2021. And they weren't out there doing audits and investigations, they weren't doing
Yeah.
inspections. Fewer people working means fewer claims. And the low hanging fruit is to do a random audit, on companies or do audit and say, hey, this company, this store has workers, but I think there should be employees. So it's a big issue. Requires a lot of
Yeah.
a lot of guidance, I think, in my opinion.
Yeah. Yeah. That's a great one. I know we've seen clients that have, going through their records, they've had those challenges. Um, so now when we come back to the hot topic of non-competes,
Non-competes, yes.
and you do a lot of work with non-competes, and let's talk about some of the changes that have affected employers around non-competes, and then also you help employers still get some of the benefits of that were offered by non-competes, but in other ways. So let's first of all,
Right.
let's just talk about some of the changes around non-compete agreements for employees that you've seen that are happening.
Sure, Damon, sure thing. And by the way, I realize how much this impacts what you do at Exit Your Way as well, because right, you have clients, you need to make sure they're in compliance before you can help them to, turn around and sell a business. So it's a great topic for anyone out there who might be a business owner, an employer. Yeah, but non-competes, big topic these days, right?
Yeah.
Something I've spoken about at webinars and presentations, and happy to speak about again. So what I'm seeing is a few things, right? One, I think you asked me the question, what changes are we seeing in the world of non-competes in the states?
Yeah.
Well, okay, so first off, A number of states have passed sort of minimum salary threshold to say that if an employee is working in that state, I believe it's like, let's see, I know that Illinois has, I think, right? Illinois, I think Washington, other states, I believe, have where the employee has to be making a certain minimum salary, like 75,000 in some states, 100,000 in other states, in order to be subject to a non-compete agreement. So if they're not making that, and you try to give the employee a non-compete, that can be considered null and void. And when an employee goes to work with competition, and you say, "Hey, not so fast! I'm going to send you a cease and desist letter. I'll send you a non-compete, and I'm going to sue you," you might not have a leg to stand on. So that's one change: is states that have minimum salary thresholds.
Minimum salary. Okay.
And number two, like some states are changing the scope of saying if you're an hourly worker, right, someone who's subject to overtime, not exempt professionally, then you cannot be given a non-compete in those states. I know that New York and New Jersey, Maryland are all looking at like some different classification of positions that say certain positions, professional exempt, maybe a non-compete. Non-professional administrative worker making less than a certain threshold salary, non-competes may soon be unenforceable. So that's the second area, right? You've got the salary threshold or the type of worker they are. Then you've got states like California that are altogether banning non-competes, saying if you, except for I think a very few, I believe it's an exception for the medical field, where medical research is such a highly competitive field. I believe that they don't want to lose people into working on things, so they try to. It's an incentive to keep people stay at certain hospitals. But that's how often does that come up, in the public and private employment world, right? But mostly these states have these laws that say, if you have a non-compete, it's not valid. So the thing is, if employers are really dead set on, and lastly, the amount of time that the courts are willing to enforce a non-compete has been shrinking from, when I started practicing in 1999, it was 2 years, then 18 months, then 12 months. Now it's about 6 to 12 months that you can, and by that I mean 6 to 12 months after the date of termination that they can be barred from working for the competition or starting their own competition.
Yeah. Well, that's good to know too.
Yeah. So, you've got like all these different, changes in the law. And then of course, right. So, people that might want to have a non-compete, but make sure that state allows it. If you have remote employees, especially, and they're remote in California and you're in New York, look at California law that governs. What I'm seeing though is that, between that and the court striking down non-competes more left and right, it sometimes makes sense to find other ways, as you alluded to, David, to protect your company, right? So let's say you can have a very strong, it's called a non-solicitation clause. That's mainly, like don't take our clients, don't take our employees, don't take our business, right? You can have clauses that talk about protecting proprietary information, right, from being taken and used somewhere elsewhere at another company. So, if someone's competing and you find out that they took some of your business, your confidential, trade secrets or marketing, that can be a reason or grounds to seek equitable relief, maybe to get them to stop using that, right, that proprietary information, or to sue them for money damages, or both. And also just, like you can have clauses that talk about working in a place that when you work here, you devote all of your time, effort, energy to the company. It's sort of a no conflict of interest, no conflicting obligations type of clause. So it's not quite saying non-compete, but you can read between the lines that if someone's working for the direct competition, their attention's divided, and there might be a conflict of interest. So there are different ways, without using the phrase non-compete, to have those clauses and to have protections rather that non-competes provide, without all the headaches of following the changes in the law and thinking that you're protected and then you're not. A lot of companies think I'm safe now because there's non-compete. And then the employee, spins off of their own startup with their, 5 other workers, and they realize that they're in, let's say, a state where, the non-compete's not valid, or they were fired. And some states say if they were fired, that the non-compete now is not valid, which is a very new thing. It used to be, didn't matter how you parted ways, right? I need to look again and see what state that was. I was reading about this, but I'm blanking on the exact state, but I remember that was a big thing that it used to be, the point where it didn't matter, right? If you were fired, quit, resign, mutual, simultaneous parting of ways, that it was all about, protecting the competitive trade secrets and the competition. So that's what I'm seeing a lot of. Yeah. And I'm really helping my clients with that.
Wow. This
It's
is great stuff
yeah.
this is great stuff. I mean, especially when you look at, if I'm in a state where if your non-compete should, if you're using it in a place where you can use it, you're using it appropriately.
Yes.
Um, but if you fired somebody, that might be the person that you don't want to go out and use that stuff. So it
Mm,
not being applicable if they were fired would be a really big deal.
yes,
Um, and
100%.
these other ways, the non-solicitation of, customers, employees, and using the trade secrets. That's another thing that's a
Mm,
good workaround that can help people do this.
right.
The one thing that we see every time in a business deal, every time,
Yeah.
without a doubt, the owners have a non-compete. There's
Mm,
always, the buyers always expect a non-compete for the owner from the
sure.
sale of the business.
Yes.
Now, I have to feel that that's a pretty appropriate use of a non-compete agreement.
Yes. And along
Okay.
those lines, Damon, the laws around employers, employees, it usually looks to the question, I mean, like, is the non-compete creating like a hardship, economic or impact on livelihood? And that issue comes up much more, with say, your standard worker, middle management employee, who now is let go from a job, has no income and can't work for people in their industry. But when you're, let's say, the owner who's selling the company for, say a 7 or 8
Yeah.
figure, right, or 9 figure number,
Yeah.
right? And you want the value to go to the buyer, not to have the seller then just open up a competition using all the goodwill that they cultivated and all the different trade secrets they learned. Um, Absolutely, I think that's a very appropriate use of non-compete. And I also
Yeah.
don't want to give the impression that there's never a good time for non-competes. There are certainly situations. We have some very competitive industries out there with very like AI being used or hyper
Yeah.
certain super high tech issues that if and they're very competitive, and if someone goes from company A to company B with this new, let's say, hot wireless information, they can destroy the company they worked at. So you do want to have some there is a place for them. It's just
Yeah.
that they used to be, I think, overly used way too broadly. And I think that one way to do this is to be more selective. Another thing you can have too is you can have like a paid non-compete. I see this a lot, where you agree to pay the employee. I see this now with bigger companies. The big companies can afford this, right? They say you've got a 12-month non-compete. I'm going to pay you for, let's say, 9 of those 12 months, right? Pay you like your salary was.
Mm-hmm.
So basically, the person can't claim economic hardship because they're getting paid. Now they might say, I was slowed down from finding a position that I could have been at for the next 20 years. What's going to happen when this runs out? But that really goes a long way. And people less likely
Yeah.
to challenge non-compete because they go, oh great, I can take my time, or it goes either 6 months, 9 months, or until you find a new job, whatever comes first. That's not competitive.
Mm-hmm.
So
Mm-hmm.
it's one way to do it.
Yeah.
Yeah.
And that's the one ways in the companies that I ran in the past,
Mm-hmm.
for the investment owners. We always, if we use a non-compete, it always was. It's basically like saying you're getting paid for that amount of time,
Right.
and
Right.
that's how we got around it. But it's been a number of years since we've had to have that situation. The okay,
Yeah.
non-compete.
Mhm.
So, and we talked about the COVID. What other things are changing now that you see
Mhm.
people dealing with? Because we talked about COVID, we talked
Yep.
about the non-competes, remote workers, the
Mhm.
1099 stuff. Are
Mhm.
we seeing other compliance issues? Like, because
Mhm.
you talk about one thing that was pretty interesting, and I think
Yeah.
a lot of people deal with is the enforcement. Are you seeing that overall, like the tax or these employment compliance are getting more aggressive because of could be that tax revenues are down?
I am. I see it more with the Department of Labor and with the Workers' Compensation Board of different states. Mainly just because I don't really do tax law, so I usually refer
Yeah.
my clients to one of my good
Yep.
colleagues, might be say a tax lawyer or and a CPA combined.
Yep.
I usually tax issues come up, but if it's actual real IRS issue, I'm going to refer to like Yvonne Court, let's say, or Jack Sullivan out here in New York. In New York. But what I
Hmm.
say is that I am seeing a much more aggressive, push. Not only am I seeing the Department of Labor come at people with random audits and with, taking complaints very seriously and just kind of looking into industries to see if there's any wrongdoing. I'm actually seeing the Department of Labor pick up where they left off 2-3 years ago before the pandemic. I mean, it's unbelievable.
Really?
Oh, yes. I've had 3 clients in the last 8 months, whatever. No, same, since what's this now, September? Since February,
Yeah.
7 months, where they came to me, and one is a client I've had for like 4 years now, right? Or 5 years. So I represented him in this situation, Department of Labor, in 2018 and 19. And then the trail kind of went blank on the issues of alleged unpaid minimum wage, overtime, and supposed obstruction, which was not even what happened, but which is very fact specific. They claimed that he obstructed an audit or an inquiry, and it wasn't true, and we had to. But the facts are they sort of disappeared in 2019, and then COVID hit in March 2020, and the DOL, Department of Labor, got swamped with, as you can imagine, unemployment insurance claims, like unemployment, all kinds of issues with tax, left and right. They lost workers. Some people quit. Some got sick. And some took off. So they just lost sight of these things. They're actually coming back to them with full force and gusto, and it's really unbelievable. You think there'd be some sort of a statute of limitations, right? Almost like in private litigation, right? If you abandon your case, it can be dismissed for that. Abandonment of prosecution. But the Department of Labor is not bound by that. So I've seen situations where they come back. Yeah, I've had at least 3 clients now, and a couple of them where, and I remember saying, you're writing to me in April, and you're writing to my client, certified mail. You're assessing penalties for, $18,000, and you're basing on this investigation that I'm looking back at emails and letters, and we haven't talked in, 3 years. And then so it's almost comical when they say your response is due by April 22nd. And it's like, hold on here, you got 2.5 years. My clients had 2 weeks. No. So we usually get, more time to investigate and respond. But so I mentioned that, if you're a company out there, and I can only really speak for New York a lot, but if you're, I think a lot of states are seeing this. My colleagues in other states, in Florida, in Illinois, in Ohio, are saying, what's going on here? So if you're a company and you had an issue with Department of Labor and it's been on the sort of the back burner, on the shelf, don't be so sure it's over yet. And I hate to say that in like a scary way, like a scary movie, but just be diligent. Make sure you're following the laws and having counsel to help you out with these things.
Yeah, that is really something, because it's a scary thought to think that you got it done and come back, and it comes back to haunt you.
Let's just say the expression "no news is good news." Not true with the Department of Labor or the Workers' Compensation Board, for most states.
Yeah.
No news is they got too busy, and now they're coming back, to you. And and the clients, my clients, the employer, business owners, are understandably pretty upset because, they're thinking, I got to go back and revisit this. I don't even remember these, who worked there even now? Who's still around? The records from 2018, are you kidding me? I'm a small business. Go to a computer system that got trashed. Now we have a new servers, and I don't know if I had the schedules for 11 workers in 2020. So it's a challenge. It's a challenge.
Yeah. Oh, interesting, because I think that we're used to in business, if no news for a long time is everything's okay, and it's not in that case. So that's a good thing to know. All right. Well, Eric, it's been awesome talking to you. And then now people, I want to also tell people you're on Talk Radio NYC with a show. What's your show called, so we make sure everybody knows what it is?
Sure. My show is called Employment Law Today. In fact, I had an excellent guest just a week and a half ago, talked about all these similar issues. Damon Pasulka. Damon was on my show. I have the show airs on Talk Radio NYC. It airs on internet radio, that's the audio, and then it airs on Facebook Live, usually at the station, every Tuesday night from 5 p.m. to 6 p.m. Eastern Standard Time. I have guests talk about some of those novel issues and challenges, such as what I'm talking about tonight, perfect example, that employers and business owners face today. So we talk about everything from inflation to the Great Resignation to the 4-day work week. And we talk about tax issues and employee morale, employee culture. So I have guests each week, and we have a great exchange. It's an hour-long show. It also does stream live on, or rather streams on, I should say, Apple Podcasts, Google Play, Stitcher, Spotify, Amazon Music as well. So tune in Tuesday nights, 9 p.m. Yes.
And that's the thing I think really is awesome about what you're doing, Eric, because you're helping to educate business professionals about employment law and the other issues around it. And that's, I felt fortunate to be on your show, and I really enjoy your show from the standpoint of that, the education that you're giving the employers so they can figure some of this out and then just really understand, make informed decisions. Understand these things better so they can make informed decisions and figure out when it's time to talk to a lawyer or when it's time to talk to another professional, because a lot of times the business owners are left guessing, and your educational efforts are really helping that. So thanks so much for that.
You're welcome.
Now,
yes.
Well, how can people get a hold of you if they want to talk to you? Because you practice law in New York and New Jersey, correct?
I'm in New York. I'm of counsel to a few New Jersey firms, so I can certainly practice there. I'm in
Okay.
the waiving process, but that's why I mentioned New Jersey. But so I'm in New York, and for all intents and purposes, I can do New Jersey with my co-counsel out there. So
very good.
So yes, so New York, New Jersey. And how do people get a hold of me? You're asking, right?
Yes.
Great question. Well, so you can find me. My website is www.sarver, S as in Sam, AR, V as in Victor, ER, -law, LW.com. The law of Eric M. Sarver. And you can find me. My email is EMS, so it's like Eric Mitchell Sarver, EMS at sarverlawfirm.com, same spelling.
Okay.
And they can also call me. Best number is 917-930-8684. I'm happy to talk with you. If you have an issue of compliance, employment, business law, contracts, what have you, I have a big soft spot in my heart for the small and medium business owner in various industries. So that's how you can reach me, Damon. Yeah.
Awesome. And we glossed over your background a little bit. I mean, you've been helping people for over 20 years doing this. I mean, you've seen a lot. You've been able to help a lot of people, and I really appreciate you stopping by today, Eric, and helping us. And for those of you that maybe joined us late, may have just got up, we got Eric Sarver here from Sarver Law Group, and practicing in New York, but he talked a lot about non-competes. We talked about remote workers and some of your challenges with that. We talked about 1099. We even got into arbitration because that came up in what you were saying, but a lot of good stuff in here for people that are wondering about compliance and other things. So thanks so much for sharing your knowledge with us today, Eric.
My pleasure, Damon. A pleasure to be on the show. Thank you for having me on the show. I really appreciate it. Great to be here.
Yeah. Well, it's a pleasure's ours. Thanks everyone for listening. We will be back again next week with another awesome guest on the Faces of Business. So keep the questions coming, and we'll keep the answers going as well. Have a great evening, everyone.
Have a great night.